Okay, we're ready to go.
Good morning. May it please the court, Michael Effman on behalf of the appellant Sean Imke. I'd like to reserve 5 minutes of my time for rebuttal.
All right.
There's two claims in this case. I'd like to begin with the second claim. I'm hopeful that that'll be the easier one to resolve, and then I can turn to the more difficult claim, which is the first claim. In the Champagne case, this court did an extensive analysis of the relationship between the lowest permissible score on a score sheet and a case involving multiple counts and how those two interrelate with each other. And the court, after addressing several issues, ultimately certified the question regarding that relationship to the Florida Supreme Court. Unfortunately, Mr. Champagne was pro se and he did not seek further review. So the Florida Supreme Court did not address the question in Champagne, but fortunately, the 50CA recently certified the same question in Gabriel, and Gabriel has been accepted by the Florida Supreme Court. The briefs are currently being prepared. So regarding the second claim, I obviously acknowledge this court is bound by Champagne. I would simply ask this court to, when resolving this case, either cite to Gabriel or cite to Treadway, as the court recently did, to preserve that issue for Mr. Imke, depending on the outcome of Gabriel in the Florida Supreme Court. So unless there's any other questions regarding the second issue, I'll turn my attention to the first issue. And I'll preface my argument by acknowledging that this is a very difficult and sad case. In 2020, our criminal justice system still does not know how to deal with those defendants that have severe mental health illness. And there's no question in this record, it's undisputed that Mr. Imke has severe mental health illness. But there are a couple points I'd like to make that I think are relevant to at least putting this case into perspective. The first is, at the time that my client was most recently sentenced, he was only 29 years old. He was still relatively young. He still has a full life ahead of him. And similar to that, or in relationship to that, the second point is that he had never been to prison prior to being sentenced to prison during the most recent sentencing hearing. So he was in trouble with the law back in 2010 in Manatee County. He was put on probation. And then ultimately for this most recent sentencing hearing, he was given a de facto life sentence, a sentence that, given his life expectancy, will mean that he spends the rest of his life in prison, and there's no parole in Florida. That's an extreme acceleration to go from one strike, we'll give you a second chance, 2 strikes, you'll go to prison for the rest of your life. I recognize that might lead to the next question, which is, Mr. Offerman, you agree that there's violent people out there, that the only way to deal with them is to put them in prison to protect society. And of course, I do agree with that. There are serial rapists, serial murderers, and the only option is to put them in prison for the rest of their life. I would submit to you that Mr. Imke is not in that category. I don't want to get into a long debate about whether or not child pornography is a victimless crime. But again, I think that the record is undisputed that he's not, my client, Mr. Imke, is not at a high risk for actually having contact with any persons, let alone minors. And he's not at a high risk for engaging in inappropriate sexual contact with an actual minor. He is at risk for probably for the rest of his life for engaging or looking at child pornography. So what do we do?
Mr. Offerman, I think the court was cognizant of that too. But we have somebody who's competent. He's not insane, but he doesn't think viewing child porn is wrong. And there's evidence in the record that he threatened to kill his mother. Now, I know that you're painting a picture of an introvert, a 29-year-old introvert, but it's indisputable that the sentence is legal. This is not an erroneous sentence legally. You're seeking something that's discretionary. And I think you can look at this record, and the court took to heart either your or your associate's request to put him in the state hospital, but legally, that trial judge couldn't do that because he had not been found guilty, not guilty by reason of insanity or found incompetent. So the prison system was the only alternative, wasn't it?
I disagree. So there are 2 legal points that I'm making. One is that the judge didn't properly consider 921.0026 2D. And second, more directly to your question, Your Honor, that it is an abuse of discretion in light of these facts to have given a prison sentence as opposed to the alternative that was being requested by the defense. So what was that alternative? Dr. Rainier said, he was very candid, that Mr. Emke cannot be at large in society right now. The only treatment that he can properly, the only place where he can receive proper treatment is at the Florida State Hospital. But in contrast to that, when asked whether he can get treatment in prison, he specifically said that he will not get any treatment in prison, and conversely, he'll be brutalized for the rest of his life. So Dr. Rainier said that he can receive the type of treatment he needs at the Florida State Hospital. So how do we get there? And again, I come back to, it's sad that in 2020, our court system still does not know how to properly deal with someone with mental health illness. We're starting to deal with addiction.
Just to stop you on that point, it's really not the court system. There are no assets provided by the legislative branch for these people. I mean, we can't put people, and as you know, we sentence people, we don't determine where they go. You know, I mean, that's up to the other branches, but I mean, the bottom line is there is only the Florida State Hospital. And it seems to me where you're going with this is you want a shorter sentence so he will more quickly be considered to be civilly committed at the hospital. Is that basically it? I mean,
that's exactly right, Your Honor.
Yeah. I mean, and with the length of the sentence he has, he's not going to be considered for civil commitment until he's 80.
Correct.
Yeah. Okay. And so it's within the discretion of the judge to have, you know, come up with a shorter sentence, but the judge exercised the discretion the judge had and chose not to depart, right? I mean, so, I mean, that's where we are. I mean, it's an abuse of discretion that he chose not to depart, and the only way to get where you're trying to go is he would have had to depart. So help us with that. How's it an abuse of discretion?
Because under these circumstances, again, with the background that I gave you, someone who's never been in prison before, someone who's not at high risk for ever actually coming into contact with another individual, Florida State Hospital is the option. So, of course, on the one hand, someone might say, well, Jimmy Rice, there's a procedure to go through that. Who knows if he'll even qualify? But Mr. Emke, in this case, specifically waived consideration for Jimmy Rice, specifically said that when we get to that point of my sentence, when I would be released, I will allow myself to be civilly committed, so pursuant to the Jimmy Rice Act, so I can receive the treatment I need to receive at the Florida State Hospital. So in light of that fact, and in light of the fact that the judge said that, or I'm sorry, that the expert, Dr. Rainier, said that's the only place he can receive treatment. There's no treatment option for him within DOC. And it's an almost certainty that he will be subjected to Jimmy Rice Act treatment. This is a case where when he gets to the point in time of his sentence that he would be evaluated, again, he's waived all rights that he would have. So assuming that they find he meets the criteria, Dr. Rainier candidly said he meets that criteria. If there's some miraculous change in whatever length of sentence between now and then that he doesn't, then that's a plus for the system. And then of course, any backside probation with conditions that would be imposed would still catch him at that point. But the strong likelihood is he will be subject to Jimmy Rice Act treatment. And at that point, he can be properly treated and perhaps pursuant to Jimmy Rice Act procedures, ultimately successfully be treated. And
all that's kind of a given, but where we are is abuse of discretion for failing to exercise the second prong of the statute and depart. So we have to find that no reasonable judge would have done what this judge did. And to use your own words, while it's it's an almost certainty that he would be civilly committed and that he did in fact waive, any Jimmy Rice type hearing, it's not a certainty. And it's also pretty much overwhelmingly evident that he is a danger to society. I mean, he is not, he's a violent guy. He's a big guy. He is, given these, he's a pedophile. And so this judge was careful with a big, dangerous guy who's a pedophile, and obviously made the decision that the only place he knew that he could not be out and hurt people was in prison. Now, I mean, a lot of judges might have made that call differently and might have been very interested in the argument that you have made. And I find it a very compelling argument that you have made, but I cannot find that no reasonable judge would have done what this judge did. And that's our standard, isn't it?
It is abuse of discretion. I acknowledge that going in. I would slightly disagree with some of the characterizations of Mr. Emke. Him being a big guy, I think Dr. Rainier was very clear doesn't make it so he's intimidating anyone else. In fact, the doctor was very clear that he'll still be brutalized and is being brutalized in prison.
Well, did I misread this? He's not just a big guy. He's a mercurial guy, an explosive guy, a potentially violent guy. A big guy with a hot temper is a dangerous guy, isn't it?
Well, again, just going back to what Dr. Rainier said. Dr. Rainier said he's threatened violence, and it's mainly been towards his mother, and it's mainly been when his mother's tried to socialize him. But beyond that, I'm not aware of any violent behavior. He's never been accused of engaging in any violent behavior. It's only been threats of violence. But you're right, Your Honor. Again, Dr. Rainier is very clear that he suffers from severe mental illness. But again, I don't think it's the type that he is, in fact, a threat to society moving forward. I think Dr. Rainier was pretty clear that, in fact, he's probably going to be by himself the rest of his life unless he receives some type of proper treatment. If he's receiving proper treatment, then hopefully we're dealing with this issue in the future. Let me switch then to the other argument that I raised as part of this, and that is that I think the judge got it wrong regarding 921.0026. So if I use this as an avenue as to why the sentence should be reversed. Because if the judge, now I acknowledge the judge did find that there was a valid basis under 2C, the capacity to appreciate his actions, but the judge found that he didn't meet the requirements for 2D, which he requires specialized treatment for a mental health disorder, and he's amenable to treatment. I submit that Dr. Rainier's testimony satisfies that factor. The judge denied that factor, saying that there's no treatment I can impose. Well, that's not part of this factor. The factor is, does he have the need for specialized treatment for a mental health disorder? I submit the competent substantial evidence in this record is he clearly meets that criteria. And is he amenable to treatment? I mean, Dr. Rainier was very candid, I think as any doctor would be. I can't tell you for certain whether he'll be successful at Florida State Hospital, but that's the one place where he can be treated. And so he does meet the strict criteria of that factor, and the judge erred in rejecting that. Now, if I'm correct,
let's not ignore the elephant in the room. He was charged and convicted in 2011 for viewing 20 counts of child porn. He was placed on probation. He got the sentence that you're asking for now. He got the opportunity then that you're asking for now, and he failed. He violated that probation in 2012 and got it modified. So then he got what you're asking for now. And then 2017, he gets 40 counts of child porn. Objectively, what makes Mr. Emke the exception here?
Well, Your Honor, I disagree with that. I think, yes, he got what he asked for.
No, he got what you're asking for.
No,
he got every program available. And he's still looking at child porn. He didn't steal a car in 2017. He upped it. He upped the ante. More child porn.
Your Honor, he didn't get inpatient treatment. And I think Dr. Rainier is clear that that's the only treatment that will potentially be successful for Mr. Emke. So yes, he got what he asked for in the initial case, but he didn't get the treatment that was necessary. The only treatment that's undisputed in this record is Florida State Hospital and the treatment they can provide. So again, in going back to the judge denied this factor, and under the 4th DCA case that I've cited, Kowalski, if the judge was wrong in denying that factor, the remedy is to send this back for reconsideration. And I'm asking the court to do that. And again, it's kind of similar to, there was a line of cases several years ago where the courts were adding on a requirement that a defendant must show that DOC cannot provide the treatment necessary. And I think it was initially Judge Warner and then the 4th DCA, and then ultimately the Florida Supreme Court said, no, that's not in this particular requirement from the Florida legislature. All that's required is that you need treatment and you're amenable to it. Mr. Emke meets that criteria based on the only testimony presented during the sentencing hearing. The judge was wrong to reject that criteria. Therefore, and that's the first step of the bank's analysis, therefore, this case should be reversed for resentencing for proper consideration of that factor, the 2D factor. And at that point, everything's back on the table and we can hopefully come up with a more creative way to properly deal with Mr. Emke's case. But I echo what defense counsel below said, and I'm quoting, this is 212 and 213, if we can't fix the problem, let's not try. That's essentially what it boils down to. That does not mean that we should just throw him away for 50 years because we can't fix him. That's just something I don't think as a society or a court system is something we should be backing. And I submit that's true. Mr. Emke shouldn't just be put in prison for for the rest of his life without any opportunity for treatment. There is a place where he can be treated, and the court system should afford him that opportunity. And therefore, I'd ask this court to reverse.
And you're at 15 minutes right now.
Thank you. I'll reserve the rest of my time for rebuttal.
Okay, thank you.
May it please the court. Jonathan Hurley, representing the appellee, the state of Florida in this case. Your Honor, I'm going to avoid the policy arguments for now. I think we'll leave that to the legislature. I'm just going to focus on the legal arguments presented before you today, starting with the subsection 2D and whether or not the court erred with regard to finding that basically the court found that the defense did not present evidence sufficient to demonstrate he was amenable to treatment. That's the long and the short of it. And that was the burden was on the defendant to prove by preponderance of the evidence that he was amenable to treatment. At no time, if you review the record, does Dr. Reginier definitively state, as the doctor, the expert in Kowalski to distinguish the two, does he ever state this in our case, that the defendant is amenable to treatment? He says that ideally he would be placed in he said the only place he could be placed, the defendant placed, is in a lockdown facility like a state hospital pursuant to Jimmy Rice. That was the only option that was presented as evidence to the court. The court realized that it doesn't have the authority to do so. So in essence, there was no option given to the court, no evidence, not a preponderance, not 51%, no evidence given to the court to demonstrate that the defendant is amenable to treatment. Just as so that's distinguished. Also in Kowalski, the court found that that defendant was not did not have a mental disorder, where in this case, the court accepted the fact that this defendant does have a mental disorder, that this defendant does require specialized treatment. Under Part 2D, Step 1 banks, the court's sole focus was on the final criteria of that subsection, whether or not the individual is amenable to treatment. That is it reasonably possible that this person, given the specialized treatment, would be successful? And I think if you court, Judge Sleet, Morris, you summarized it well when you look at the facts. This was not 2 strikes on this individual. This was 3 strikes. 3 strikes, you're out. The first one was 210, 211, the initial offense of possessing child porn. Then he violated willfully and substantially that with more, both combination of child and adult porn. That's 2 strikes. And then we have the most recent new offenses where he's charged with 40, but according to the state and the record, there was somehow over 500 images and so forth. And this, again, was not just a one-off. This most recent new offense violation, it was being investigated for an extended period of time. So it wasn't just he just turned on the TV one time and watched porn. This has been ongoing. In essence, you could infer that it's been ongoing all along. It's been ongoing since 2010. This has been an ongoing problem, and this is a harm. This is a ongoing harm to children. There's no dispute about that. So the trial court also has to weigh that situation out. So the court was left with no options in this particular case with regard to Step 1. With regard to subsection C, where this is a judgment call, strictly abuse of discretion, a judgment call by the court. Again, I think your honors have summarized it. The court looked at both the mitigating and aggravating situations, looked at the history that this person was Baker acted twice. When he was in school, he couldn't be retained in school because he was violent towards teachers. He was violent towards his mothers. He has fantasies, violent fantasies. The doctor acknowledged that under no circumstances should this defendant be left alone with a child. He was in possession of a child's bathing suit and using that to pleasure himself. So this is an ongoing threat, harm that the court has to consider in the totality of both mitigating and aggravating circumstances. There was absolutely no abuse of discretion on that judgment call in regards to 2C. I don't know if there's further questions regarding this. I'd be happy to take further questions. If not, the state would respectfully request that this court affirm the sentence below. Thank you.
Thank you, sir.
May it please the court. I'll be brief. I think the court understands my position, understands both my my legal arguments and my arguments that are hopefully tugging at your heartstrings. And that's not something I normally say in an oral argument, but this is a tough case. It's tough for me personally. I have a child with special needs. I think in 2020, we need to get to the point where we start treating mental health illness. And I understand.
Offerman, I don't necessarily disagree with your policy statement, broadly speaking. I do have a question about your view of judicial discretion in sentencing, because so far what I've heard in your entire argument, very well articulated argument, but it almost sounds like you view the trial court and the court system as the point of reference for mental health counseling, which we are not. What role does punishment have in your view of the exercise of judicial discretion in sentencing a man who over the years has been found repeatedly guilty of possessing lots of child pornography?
No question, the criminal punishment.
And he's competent. He is competent. He may suffer from some severe mental illness, but he is competent to be sentenced and to stand trial.
No question, our system says that the primary purpose of sentencing is punishment. I acknowledge that. The legislature has said that. I don't think anyone was arguing he shouldn't be sentenced to some term of imprisonment. The question is, should he spend the rest of his life in prison? And right now, the way it stands, there's no parole. He will be in prison for the rest of his life. So I understand that there's an interplay between the legislature, who has the ability to control the purse strings and come up with more creative solutions, but I don't think that means that the judicial system just has to sit by and do nothing, especially when there is a creative alternative in this case. I've made my legal argument as to why it should go back for resentencing under 2D, and I'll stick by that. I won't repeat that. But regarding the abuse of discretion, I submit that it is an abuse of discretion because it simply comes down to where should Mr. Imke be right now? I don't think any reasonable judge ultimately thinks he should be in prison for the rest of his life. I think this judge truly believes also that he should be able to get to the Florida State Hospital, but the judge said, I can't do it. I think that's where the judge was wrong and abused her discretion. There is the answer here. Once he completes his prison sentence, we know for sure he will be reviewed under Jimmy Rice. He's waived his Jimmy Rice due process rights, so he will be sent to the Florida State Prison. The only way
but to be clear, though, no judge has the ability to send any defendant to the Florida State Hospital. Okay.
But the system does.
That has to occur at the end of a sentence.
It does.
And that's right. And it has to occur at the end of a sentence where there are additional hearings and additional expert testimony. So it's not a sure thing. It may or may not happen.
He's waived it. So from his standpoint, and he can be bound by that waiver, he has waived any of those hearings. So if it doesn't happen, it's not the judicial system's fault. it's a fault with someone else in the system. Now,
No,
so we can,
but that's not how a judge who's sentencing thinks. The judge who's sentencing says, I have a responsibility to the community to protect them from this person who has a pattern and a history of engaging in this harmful behavior. So, judges don't take the position, oh, it's somebody else's problem if he gets out. I mean, judges are worried about this,
well,
you know?
and I'm not being that callous about it, Your Honor. The sentence would be, I am sentencing you to prison. There is a punishment aspect of this, but I am now going to then give you probation that has house arrest and requirements of counseling and treatment and all these other things. But I also know that I'm putting as part of this sentence, you have waived your ability to challenge Jimmy Rice. So consistent with Florida law, at the conclusion of your sentence, you will be evaluated to determine whether you meet the Jimmy Rice criteria. And should you meet that criteria, you will be civilly committed pursuant to all the procedures that are in place for Jimmy Rice. A judge can say that with certainty that Florida law requires that process. So if that process is followed, and it will be in this case, is there a chance that it might not be? But that's not something that the judges would take into the calculus. And then if you're weighing those types of things, is it a possibility that he might slip through the cracks or someone might miss him for Jimmy Rice versus do I send him to prison for the rest of his life? Again, at some point, we are in 2020, we are dealing with someone that has a mental health issue. We have to deal with the mental health issue. We can't just keep putting people in prison and locking them away for the rest of their lives.
That's a great speech, and you should deliver it to the legislature.
I hope that somehow, some way, the court will find it to come up with a creative option to give Mr. Emke an option, some type of chance at life, because the way it stands right now, he won't have any life and he'll continue to be brutalized in prison, just as Dr. Rainier said. So with
And
that,
you're out of time, sir.
thank you.
Thank you. Thank you both. Very well argued. Thank you very much. Our next case is